Please note that the information on Retire Vivid referenced in this video is accurate as of October 11th, 2024. Changes to laws and regulations may make portions of this segment outdated and no longer relevant. The information presented is for educational purposes only and is not intended to provide investment, tax, or legal advice. Please see our full disclosure at the end of this video.
Welcome to Retire Vivid. I'm Cameron McCarty, and today's episode is a good one. We're going to be talking about estate planning, wills, trusts, power of attorneys. I think we're going to talk about asset protection from long-term care costs, and that's why we have a special guest today, Mr. Matt Bollman. Matt, thanks for joining me.
Thanks for having me, Cam.
Hey, so I got a lot of good stuff we're going to go through with you. But before we begin, why don't you tell the viewers a little bit about yourself, your law firm, and let's go from there.
Yeah, I'm an attorney at Pearson Bollman Law. Pretty narrowly focused law firm, so all the attorneys really do the same thing. So we practice an area of estate planning, so that's wills, trusts, power of attorney documents. We do probate trust administration, so that's advising the executor or the administrator through the probate process, or the successor trustee through the trust administration process. We also practice an area of elder law. Usually for us, that's Medicaid planning or VA pension planning, and then we do litigation related to those practice areas. We have an office kind of throughout the state of Iowa. We've got one here in West Des Moines, up in Dubuque, Bettendorf, Cedar Rapids, up in Okoboji, and we just opened an office in Overland Park, Kansas.
My goodness. So you know what you're doing, to say the least.
Well, we try.
Well, I'm glad you're here. No, I mean, you do a lot. I mean, Matt does a lot of our plans for our clients, especially when it comes to estate plans, because one of the things we preach, and we talk about this all the time, is having that team. Right? We talk about that all the time. And so we feel it's so important where you collaborate as one, because we can't be everything to everybody, no different than you with your clients. And so that's why we have such a great relationship. Now, what we really try to get people to look at is this. It's like, okay, so many times, this is what we see, where people would go to a tax professional. You know, you maybe meet with them once a year, you pay them a fee, and then you leave. Then you go to a whole separate office. You go to see your financial advisor. You know, they help you with your retirement plan, your investments, you name it. A whole nother office again, and then you leave. And then your attorney to help you with your estate plan, your wills, trust, power of attorneys. But again, nobody talks to each other most of the time.
Right.
We feel that it's so important to bring that team together.
Yeah, absolutely. I mean, you have to have a coordinated plan. You know, when somebody passes away, some assets are going to be controlled by the will or the trust. Some assets are going to be controlled by the beneficiary designation form. You have to have a coordinated plan in order for all of the assets to make sure they're going in the correct place.
Matt, let's dive in, but before we get into wills and trusts, what makes sense for people, let's talk about the foundational documents.
Yeah.
Why don't we start there and kind of bridge off of that?
Yeah, so whether you go down the path of having a will-based estate plan or whether you have a trust-based estate plan, we always make sure that you have the foundational documents. So that's making sure that you have a financial power of attorney, healthcare power of attorney, and a living will.
I mean, you always talk about this, it's just having an estate plan in order to protect everything you own and also everyone you love. But these are documents while you're alive, right?
Yep.
And so let's first talk about the financial power of attorney and why that's such an important document.
So that's you're still alive, unable to make financial decisions. Who's going to be your substitute financial decision maker?
So, but here's something real quick that I think is important to talk about, because people would say, well, hey, Cam, I'm just going to list my son Jerry on my bank account. You say, don't do that.
Yeah, I mean, it's a common mistake. What happens if that son Jerry gets into a car accident, gets into a divorce? You're
A lawsuit.
You're opening that account up to potentially his creditors losing that account. And
so by having this financial power of attorney, that can help, really put that buffer, if you would, in terms of protection with that one asset.
Yeah, I mean, it handles that situation where in the event that you do lose capacity, you've got your substitute decision maker because they have that document.
So get this document.
Absolutely.
Very, very important. Okay, now let's move on to the next one.
Yep.
Healthcare power of attorney. I mean, so this is to help make healthcare decisions. But let's talk about this one real quick.
Yeah. Again, unable to make healthcare decisions. Who's going to be your substitute healthcare decision maker? Kind of the big issue we see here is people do the document, but then they don't give it to anybody.
Yeah.
So the hospital doesn't have it. Their healthcare agent doesn't have it. So
Right.
make sure that you have it scanned at the hospital.
Now, one thing I wanted to bring up is, be sure that it includes the medical HIPAA release language. I mean, can you talk a little bit about that?
Yeah, I mean, if you haven't had this document updated in maybe 12, 15 years, it's potentially missing that HIPAA medical release information language. So, this isn't a one and done document. Make sure you have it updated every so often.
Okay, and a lot of times the healthcare power of attorney will include a living will, right?
Yep. A lot of Iowa attorneys use the Iowa Bar Association forms, and oftentimes the living will and the healthcare power of attorney are on the same form.
They're on the same form, and so this is the one thing, if anything, just making sure that you get these foundational documents. I mean, Matt, do you run into a lot of people that just don't have these documents?
Yeah, I mean, it's surprising to me that, I do run into a lot of people. I review a lot of estate plans, and for whatever reason, they've got a healthcare power of attorney or they have a financial power of attorney, but they're missing the other documents. So just double check that you make sure that you have all these documents.
Very good, very good. Well, next I want to talk about wills, trusts, but before we do, we're going to take a quick break. So make sure you stay with us. We got a lot more coming up.
Do you have questions about your retirement plan, or do you want to know if you are on the right track? We are here to help. Simply go to retirevivid.com or call the number below to schedule a 15-minute retirement review. You can speak with us about taxes, Social Security, your 401k, or any quick retirement questions at no cost to you. We are here to make retirement vivid. Schedule your 15-minute retirement review today.
Welcome back. If you just joined us, we're talking about estate planning today. We just got done talking about the foundational documents, making sure we have those power of attorneys. That's why we're alive, okay? Now let's talk about documents when we're gone? I mean, so we got wills, we got trusts. I mean, let's talk about these two different types of estate plans, Matt.
Yep. Yeah, I mean, when we talk to clients, we're generally talking about, either having a will-based estate plan or having a trust-based estate plan.
Sure.
And there's two primary differences between the two. The first big difference is when they become effective. A will-based estate plan does not become effective until after you pass away. Whoever you've named as the executor in that document will take that will to an attorney. The attorney will do the opening probate paperwork. They'll file that with the court. That's when the will becomes effective. Whereas a trust becomes effective as soon as you sign it. It basically creates a new entity, an entity that can own assets while you're alive, an entity that can exist after you pass away. The next big difference is how they're administered. A trust-based estate plan is administered through trust administration, whereas a will-based estate plan is administered through the probate process. Probate is that court-supervised system of administering assets.
Right. So really, I mean, going through the courts versus more of a private family matter, if you would. Let's stay on this for a second. I want to talk about a will.
Yeah.
A will-based estate plan. I mean, each plan fits different people, Matt. I mean,
Exactly.
I know you would attest to that. But there's pros and cons of each. I want to first talk about the will. So, the biggest thing here is this. Wills equal probate. Am I right?
Correct.
Okay.
Yeah, and that's kind of a common misconception with people in my office. They're like, well, I just did a will. I thought I was setting my estate up to avoid the probate process. But,
right.
Clearly wills equal probate. And there's just some reasons that, we want to make sure that people understand what the probate process is. Probate process is court supervised. So, there's no privacy. Anybody can go down to the courthouse. They can take a look at your will. They can take a look at your inventory. They know what you had. They know who it's going to go to. So that it's public information.
Public information. Yep.
The next is, you've got the court involved. You've got a law firm involved. It can be somewhat of a lengthy process. And then lastly is the cost aspect. And usually that's the biggest driver as to why people want to avoid the probate process. So the costs are statutorily defined. So the statutory maximum an attorney can charge is 2% of the gross estate value. The attorney can charge 2% of the gross estate value. And then the court costs are 0.2% of just the probate value.
Okay, so let's put that into perspective. So let's just say that we've got $1 million estate.
Yep.
Okay, and so this would be, again, we'll talk about this in a minute, but let's say we got a home, some assets, even though you got beneficiaries. We'll come back to that here in a minute. But Matt, let's break that down in terms of cost. So $1 million estate, walk us through it.
Yeah, potentially, if everything is being, characterized going through the probate estate,
yep.
that could potentially be $20,000 in attorney's fees, $20,000 in executor's fees, and ballpark $2,000 in court costs.
That's a lot. It can be.
It can be.
It can be.
Yep.
I think the biggest one when it comes to a will, again, it fits different people. Real quick here, let's talk about that. Who does a will fit?
Yeah, certainly a will is an easier plan for you to have.
Sure.
Maybe it's more complicated for administration because it's going through the probate process. It's certainly less expensive for you to set up.
Sure.
And then if you're not a very organized person, a trust-based estate plan probably is not going to ultimately work. Your beneficiaries are going to end up in the probate process anyway.
Right, but you've also had it where you've worked with people that maybe had, you got to do the math.
Absolutely.
Right? In terms of, does it make sense to have a will, go through probate versus paying for a trust, to work on eliminating probate. But people just might want the privacy end of it.
Correct.
Even if it doesn't make sense to have a will, but it really comes down to people's individual situations.
Correct.
All right. Well, that's okay. So that's a will. Now let's move on to trust-based estate plans. So let's walk through this because, again, the reason why somebody may set up a trust is maybe the privacy end of it, and maybe they want to avoid probate. Walk us through this.
Yeah, I look at trust-based estate planning as you trying to organize things today to make it easier and less expensive to administer at the point that you pass away.
Okay.
So kind of walking through the same issues. So instead of going through the probate process, we're being administered through the trust administration process.
Right.
So, privacy, it's being handled in a more private family situation. Timeliness, again, it's very similar steps that occur in the probate process, but it's not having to go through the court system. So generally, it's usually open and closed faster than the probate process. And usually the costs are cheaper because you're avoiding the court costs. Oftentimes the trustee fees and the fees associated with the attorney are usually charged either on a lower percentage or on an hourly fee, reducing fees in that situation.
Okay. So again, and there's different types of trust. I think the one that we're talking about right now is a revocable trust, correct?
Correct. Yep.
I mean, we'll talk about irrevocable here in a little bit, but I want to talk about no different than the wills. I mean, for people that may be candidates for a trust. Let's walk through that.
Yeah, I mean, usually, it's certainly the people that are looking to avoid the probate process. So it's looking at, I want to get things organized today to make it easier and less expensive to administer at the point I pass.
Got it. And so for people that maybe just feel privacy is the utmost important thing for them, a trust may make sense for them.
Correct. Yep.
And then the other thing too is they want to simplify that process.
Yep.
Right? I mean, I'm assuming that's what you hear on your end when you're doing trust-based estate plans for some families.
Yep. Potentially want to eliminate the court costs, reduce the attorney's fees.
Right. Right. We don't want to do that, do we?
Well,
I got you on TV, Matt.
Some clients certainly want to in that situation.
Oh, I love you. I love you. Okay. But you also are a big believer in adding different types of trust in part of your plans.
Yeah, so, whether you do a will or whether you do a trust, we are big believers in having backup beneficiary protection plans built into your estate plan. We've certainly administered enough of these that you just do not know what your beneficiaries are going to look like at the point you pass away. So we always build into our plans an underage trust, or an incapacity trust, or a supplemental needs trust. So at the point you pass away, your executor or your trustee is going to look at each beneficiary. And if somebody is underage, we're going to hold their assets in a trust. Or if they have a drug or alcohol problem or otherwise don't have capacity, we're going to hold their assets in a trust. Or if they became disabled receiving asset-tested government aid, again, we're going to hold their assets in a trust.
That's a great idea. I mean, because again, especially if they are in government assistance, you don't want to knock them off of that. And if especially, every family is different, in terms of if somebody has a child that's maybe more responsible than, I don't know.
Correct.
But that's why you have these in place, because you don't know what your beneficiary is going to look like the day you pass away.
Absolutely. Yep.
And again, folks, this is why we offer that 15-minute retirement review. This is where you have the opportunity to ask us those questions. Today is on estate planning. You can talk to Matt, whether you have questions on wills, trusts, power of attorneys, maybe your own individual situation when it comes to your estate, or just retirement in general. So I encourage all of you to take advantage of that. Next, we're going to stay on trusts, but we're also going to move into asset protection from long-term care costs. More right after the break. Tommy, tell everyone why they need to watch our show.
Because we're helping people get retirement ready, that's why.
It's the Retire Vivid Talk Show,
You don't want to miss it.
helping you get answers to your retirement questions.
Don't miss him on Retire Vivid, every weekend on ABC.
Welcome back. If you just joined us, you missed a lot. We've talked about a lot today. Before we dive into a tough subject when it comes to long-term care, that sort of thing,
Yeah.
I want to talk about addressing other concerns real quick before we dive into that. And the first one, Matt, that people have is, their two biggest assets are usually their home and their IRA 401k. So let's talk about that.
Yeah, I mean, your IRA, it's always going to be controlled by the beneficiary designation form. So,
Sure.
Are you using named beneficiaries on that form? Do you have a supplemental needs person? Do you have a spendthrift child issue? If so, potentially you're naming a trust. So you make sure you're going to walk through those issues, and there's special planning considerations related to that.
Okay.
Are you worried about your spouse remarrying and disinheriting your kids? I had this husband-wife over in Cedar Rapids. He was 88 and she was 86. She was just concerned that if she passed away first, he was going to marry the neighbor down the street and disinherit the kids. So, if it's a concern to that age, it's always going to be a concern.
Yeah.
But
Yeah,
very easily addressed in estate planning documents.
Well, another thing too is, and I know you work a great deal with farmers.
Yeah.
Right? Let's talk about that.
Yeah, I mean, the typical farming situation is, one of the kids stayed back to farm, two of them moved off the farm. We're land rich, we're cash poor. How do we treat everybody fairly? We've got enough experience to work through those solutions.
Absolutely. It's really tough when it comes to that. You may not be able to be equal, but how can you be fair?
Exactly.
Right?
Yep.
And so again, these are things that you can help people with. And that's also why we love working with you. But real quick here, I got a couple other things too, Matt. A lot of times people say, hey, Cam, I got 3 kids, right? I have a will, I have a trust or whatever. So who do you name as, do you list them all? Do you encourage you to list one? What's your recommendation there?
Yeah, this role of who you put in charge of the administration, whether it's executor, whether it's a trustee, this person's going to be working, they're going to be working with an attorney, potentially working with a tax person. They need a skill set that is.
So really, don't necessarily pick the oldest person. You're just saying, hey, who has the best skill set?
Yeah.
But which makes sense to me. But my question is, okay, but what if you got 3 kids, 2 of them have a good skill set, one of them maybe doesn't? Do you list 2, or is it still just one person?
Oftentimes we would recommend naming one person.
Okay.
And then if you don't have somebody that does have a skill set, oftentimes we'd point you to a bank trust department.
This is a big one where people get so confused on this. So let's just say I got my IRAs, my bank accounts, and I've got beneficiaries on all those accounts. And they go, all I got is a home over here.
Right.
Why do I shouldn't go through probate, right? That's what they say. That's not true. Let's talk about it.
Again, it's that common misconception that, the exact scenario you just laid out. All of your assets, you're able to put beneficiary, payable on death, transfer on death on all of these assets. So the only asset that doesn't have a plan is the home. But that's effectively going to rope all of the other assets going through the probate process.
What I hear a lot, they go, well, why do I even need this?
Yeah.
Because you own real estate.
Yeah, all of those other assets, they're not going to be controlled by the probate process, but they will be listed on the inventory. The attorney and the executor in charge off of that extra value.
And that's why you work with somebody that's done this before. So I just wanted to bring that up. So that's really good. Okay, let's move on. I want to talk about a tough subject. It is tough in having these conversations with people, and it's getting worse, right? Asset protection from long-term care costs. Mm-hmm. Matt, there's only so many ways, in order to help cover this, but real quick here, let's talk about this. I know we've got the elderly waiver, if you're the VA pension. Let's talk about these things.
Yeah. When we talk about elder law and we're talking about, how are you going to pay for it, we work with different programs. So, we work with the Medicaid program related to nursing home care costs. We're working with facility Medicaid. Right. The elderly waiver program, Medicaid, can pay for assisted living and it can pay for home care. And then there's also a VA pension that can potentially fill in the gaps there as well. And
so again, there are different things that we need to look at. But Matt, if you take a look at, okay, am I going to need care? Statistically, it says yes, potentially.
Correct. Yeah, you can point to statistics and more than likely you're going to need some
form of care,
whether it's home care, assisted living, nursing home care at some point in your life.
And you know what? If there's anything keeping up with inflation, it feels like it's long-term care costs.
Yeah, in the Metro Des Moines area, we're seeing in the range from $10,000 to $12,000 a month.
a month. I mean, that's just crazy. It's just crazy. I mean, so then the next obvious question, how do you pay for this thing? You know, there's only so many ways.
Yep. You know, if you've made the long-term care insurance purchase, you know, we certainly wouldn't discourage that. It's just, you know, usually people that end up talking with us, you know, maybe financially at that point in their life, it doesn't make financial sense anymore. Or health-wise, they're unable to be underwritten. Or you're qualifying for Medicaid, qualifying for the VA pension, or you're privately paying.
Right.
Those are your options.
Couple things. I mean, let's talk about Medicaid transfer rule, and then I want to quickly go through irrevocable trust.
Okay.
Go ahead.
Yeah, I mean, with Medicaid, there's this general rule of, have you transferred any assets within the prior 5 years? And if so, there's going to be a penalty period related to that transfer.
I mean, a lot of times people would say, okay, well, they want to do pre-planning, right?
Yep.
And so let's talk about, we just talked about a revocable trust. Let's dial in now on an irrevocable trust.
So when I have clients come into the office and say, you know, I've got the house, I've got the family farm, I'm concerned about asset protection against long-term care costs. In that situation, we're recommending them do an irrevocable trust, basically starting the 5-year look-back period on the transfer of assets.
Okay, but let's talk about this though, of the whole control piece, right?
Yep.
Because if you do an irrevocable trust, you are not the trustee of that trust.
Yeah, you're not the trustee, you're not the beneficiary, you're effectively giving up control of that assets. That's what starts the 5-year look-back period and the transfer of assets for Medicaid purposes.
Right. I mean, so, I mean, for somebody that has something like this, I mean, is there a certain age you look at, or, I mean, what comes into a recommendation of this?
Yeah, I mean, usually just, you know, demographically, people, there's been some diagnosis of, you know, early onset dementia, or, you know, mid to late 70s, something like that.
Right, right. And of course, let's say somebody came in, they didn't do pre-planning, there's crisis planning as well too, that you offer, which I know could be tough for a lot of folks too.
Yeah, I mean, the typical crisis planning situation for us is, you know, oftentimes it's the wife still at home, just moved her husband into the care facility, got that first bill for $10,000. You know, we're able to reorganize income and assets in order to gain Medicaid eligibility.
Wow. I mean, Matt, I could keep going, but there's only so much time I got here. So this was wonderful. Thank you for going through all this with us today. I mean, I really do appreciate it.
Thank you, Cam.
And I hope that you all picked up something as well too. And so again, we are here to help you, guide you, give you the tools that you need so you can make an informed decision during your retirement journey. We'll catch you next time right here on Retire Vivid.
Cameron McCarty and Tommy Breitbach are investment advisor representatives of Vivid Wealth Management, a SEC-registered investment advisor located in Des Moines, Iowa. Matthew Bollman is a licensed attorney with Pearson Bollman Law. Pearson Bollman Law is not affiliated with Vivid Tax Center, Vivid Wealth Management, and Vivid Tax and Wealth Advisors. The information presented is not provided in the course of an attorney-client relationship and is not intended to constitute legal advice or to substitute obtaining legal advice from an attorney licensed in the appropriate jurisdiction. Investment advisory services are offered through Vivid Wealth Management, LLC. Insurance products and services are offered through Vivid Tax and Wealth Advisors, and individually licensed and appointed agents. Tax planning and preparation services are offered through Vivid Tax Center, LLC. The preceding entities are affiliated. Information presented is for educational purposes only and does not intend to make an offer or solicitation for the sale or purchase of any specific securities, investments, or investment strategies. Case studies and examples presented are hypothetical and used to demonstrate a concept. These studies do not represent actual clients or results. Similar or even positive results cannot be guaranteed. None of the entities above are affiliated or endorsed by the Social Security Administration or any government agency. Information expressed does not take into account your specific situation or objectives and is not intended to provide investment, tax, or legal advice. Listeners are encouraged to seek advice from a qualified tax, legal, or investment advisor to determine whether any information presented may be suitable for their specific situation. Past performance is not indicative of future performance. Investments involve risk and, unless otherwise stated, are not guaranteed.
Thanks for watching Retire Vivid. Want to see more? Like and subscribe to our channel to stay up to date with exclusive Vivid content. Plus, be sure to watch our show Retire Vivid every weekend. We're here to help you get retirement ready.